Hello everyone and welcome. I'm Jared Martin, a staff member at the California Evidence-Based Clearinghouse, or CEBC for short. Thank you for participating in today's webinar on the legal considerations of opioids and cannabis use in child protection cases, presented by Professor Frank Vandervoort. So a few housekeeping items. We've muted your phones due to the high number of participants attending. So if you're experiencing any technical difficulties or if you have any urgent questions, please use the Q&A pod located at the bottom of the screen, and we'll do our best to assist you. You can also use this Q&A pod to submit questions for the presenter, but please note that he will answer your questions at the end of this presentation. You'll also find the PDFs of the PowerPoint slides and other webinar relevant materials in the bottom left corner of your screen. And lastly, you will receive an email with a link shortly after the conclusion of this webinar to complete a short and easy survey so we can continue to improve our webinars and make them as useful and beneficial as possible in the future. All right. Next slide, please. Yeah. So some quick background information on the CEBC for those who may not be familiar with us. The CEBC is funded by the California Department of Social Services, Office of Child Abuse Prevention, and we're operated by the Chadwick Center for Children and Families at Rady Children's Hospital in San Diego. Our mission is to advance the effective implementation of evidence-based practices in child welfare. And the CEBC website is a publicly available resource for accessing detailed information on a broad range of intervention and prevention programs that we have individually rated on a simple rating scale according to their published peer-reviewed research evidence. In addition, the CEBC website has a wealth of information and resources to aid systems and organizations with selecting and implementing new evidence-based practices. The address to our website is located on the bottom left-hand corner of your screen. Be sure to visit our website and take a look at the interventions and resources we have, including the rated interventions most relevant to today's topic, webinar topic, which are the substance abuse treatments for adolescents and adults. And feel free to contact us if you have any questions on using or better understanding the CEBC website. So one last important note before I introduce our presenter. As indicated by the title and learning objectives, which Professor Vandervoort will review shortly with you, today's webinar is focused on the legal considerations of opioids and cannabis use in child protection. So there will not be much focus on treatment or practice level factors. The CEBC is hosting today's webinar to acknowledge that child protection systems in California and across the country are coming to grips with their state's legalization of recreational cannabis use and also the significant opioid crisis. So by highlighting the legal considerations, it is our hope that today's presentation will help guide your agency's policy planning that will then lead to improved screening, assessment, and treatment. Next slide, please. So now a brief introduction of our presenter. Professor Frank Vandervoort is a clinical professor of law at the University of Michigan. His primary interests include juvenile justice, child welfare, and interdisciplinary practice. He co-founded the Juvenile Justice Clinic with Professor Kimberly Thomas in 2009. Professor Vandervoort is the immediate past president of the American Professional Society on the Abuse of Children and chair of its Amicus and Public Policy Committee. He received a BA from Michigan State University and a JD from Wayne State University. Now I will turn it over to Mr. Vandervoort.
Thank you, Jared, and welcome everyone. I'm glad to be here. I appreciate the invitation and the opportunity to talk to you today about the impact of marijuana and opioids on child protection work that we all are involved in. My goals for the webinar today are to talk about the constitutional framework of child protection. The law, our basic law in the country establishes a framework for protecting children, and so we want to review that framework. We'll talk a little bit about the federal laws that incentivize states to create and run their child protection systems in particular ways. I want to talk about the use of illegal substances and how that impacts child welfare, and essentially to compare that to the use of these newly legal substances, specifically marijuana, which has been legalized either for medical purposes or for recreational use in a number of states now, and also to think about both the legal and illegal use of opioids. So those issues are having a very large impact on child protection and child welfare systems in our current practice setting. And I also want to talk about substance use and abuse during pregnancy, because that has become something that's very timely in terms of whether prenatal exposure constitutes child abuse or neglect, and if it does, how legal systems and courts react to that. So that's what I'm hoping to accomplish today, and I look forward to your questions and so forth. Jared, do you want to talk about the poll question?
Yeah, sure. I'll be happy to. So we have a series of poll questions throughout today's webinar. The first is what you can see on your screen, which is what service system do you work in? And so you should see a box popping up on your screen as well. That'll give you a multiple choice response. So if you could please take a second to select the field that you represents the most closest to what you work in. So you can see the responses are A, child welfare, B, behavioral health, C, education, D, public health, E, housing, F, family or child advocacy, or G, other, which is pretty much anything that's just not listed. So we'll leave it open for a couple seconds, and then we'll broadcast the results so that we can get a better sense of who's in the room with us. All right.
Okay, great. It looks like we have a lot of child welfare professionals in particular, and a fair number of behavioral health professionals. So that's terrific. A number of people working in housing as well.
Great. So we'll advance to the next question. Next slide. So next question is, what is your role? So you should also see another pop-up box come up, and the responses are, or the response options are A, director, B, administrator, C, supervisor, D, direct service provider, if you're an attorney or a legal employee, E, or F for other. So take a second to respond. All right, our response is looking.
It's helpful to know who the audience is, so thank you. I appreciate that. Ready to?
Yeah, so it looks like the majority of the folks on the line are in the other category. Maybe if folks want to type in what their positions are in the chat box, just to give us a sense of, since we didn't really capture it in the listing, if you wouldn't mind.
Okay.
Foster parent. Okay. Yeah, as folks type in, but yeah, Frank, feel free to move on.
Okay. So in terms of thinking about the basic framework for protecting children, the Constitution and the structure of our legal system thinks about this as having three parties whose interests need to be addressed and balanced in some way. And those parties are the child's parent, the child, him or herself, and then the state, usually acting through Children's Protective Services organizations, or in some states, private actors can file a child protection case, and the state action comes about as a result of the court's action if it decides to get involved in the family's functioning. So Parents have a constitutional right, which is an individual right, which is protected by the liberty clauses of the Constitution. And what is protected is their right to provide care, custody, and control of his or her children. So a parent has the right to direct the upbringing of their child without the interference of governmental authorities, as so long as the parent is fit and functioning. The right generally we think about the right as the right to select what school a child goes to decide on medical care for their child, to decide on whether or not a child, for example, might see a therapist. So it's the kind of things that parents do on a day-to-day basis in terms of raising their children. And the Constitution protects that. So I've suggested here two cases, Meyer versus Nebraska, which is the first case nearly a century ago that recognized the rights of parents to direct the upbringing of their children. In that case, a parent was allowing a child to be instructed in German language, which, if you think about that time frame, we're just in the wake of the First World War. Nebraska had enacted a statute that prohibited the teaching of school subjects in German. And so that was challenged because the teacher was criminally charged, and the parents intervened in the case, and there was a question about the parent's right to direct their upbringing. And the court held that the parent has a right to direct the upbringing of their children, including the right to choose courses in German. Pierce versus the Society of Sisters, 2 years later, very similar kind of issue. The state of Oregon had a law that required public education and disallowed private parochial education, and a group of parochial schools and parents who wished to send their children to parochial school challenged that and ultimately won the right to direct the educational upbringing of their children. The link to the parent's right to raise their child is a duty to do so in a way that meets the child's basic needs, so that a parent has the responsibility to provide adequate food, clothing, shelter, that kind of thing, to make sound decisions for their child. So while the parent has a right, that right is certainly not unlimited. In Parham versus JR, the United States Supreme Court ruled that a parent had the first decision to make whether or not a child received inpatient mental health services in a mental hospital, and only after the parent had made that decision, with the advice and concurrence of the physician, a psychiatrist, could the child challenge that decision in court. So that decision initially rests with the parent, but ultimately if the child is in disagreement, the child has a procedural right to challenge that. So the important point here is to remember that linked to the parent's rights are parental duties to the child. The second party is the child, him or herself, and the child has the reciprocal right, we think of it as a reciprocal right, to benefit from the day-to-day interactions with his or her parent and to receive that nurturance that a parent will typically give to a parent, and to benefit from the parent's guidance in terms of education, medical care, and so on. And so you see there a sort of lengthy quotation from Duchesne versus Sugarman, which is what I think of as the best articulation of this way that the parent and child's rights are reciprocal and work with each other. But it's the parent's right to care for the child and the child's right to benefit from that care and consideration and nurturance on a day-to-day basis that's really at issue when the state steps in to intervene into the family. It's important to remember, though, that children, in addition to a constitutional right to essentially be left alone, to be raised by their parent, they also have a statutory right to be safe from harm that the parent might inflict in the form of child abuse or neglect in not meeting their basic needs as a human being, right? So the need for food, clothing, shelter, adequate care, medical care, those kinds of things. So the child has these competing rights, that they have the right to be left alone, essentially, and to allow their parent to raise them, but they also have the right to have governmental authorities intervene if the parent's not meeting their basic responsibilities to the child or is in some way harming the child. It's very clear that this right in terms of children for statutory protections attaches to the child after the child is born. It's less clear how it applies before the child is born. You probably are aware of a case, Roe versus Wade, which held essentially that a fetus or a child that is not born is not a person within the meaning of the Constitution. And there's debate about whether or not a fetus, or what I will refer to later in this talk as an inchoate child, whether that entity, that person, has any rights at all. And so that's a conversation that we have, and it plays out in different ways in the child protection system. In addition, then, is the third party is the state, which has a compelling interest in making sure that children are safe and well cared for, at least well cared for at a minimal level so that they're not neglected. So the example here, Prince versus Massachusetts, that generally speaking, a parent has a right to raise the child, but the family is not beyond the state's capacity to regulate. And you see that in many different areas, things like mandatory education laws, child labor laws that prohibit children from working, and so forth. So the state's interest has been called this parens patriae interest, which essentially is, we get from the English common law, which the idea is the king is the final guardian for children. So in this country, we don't have a king, but what we have is a government, and the government is the final guardian of the child. If the parent's unable or unwilling to meet the child's needs, then the state can step in as the ultimate guardian for that child. We talked a little bit about Param JR earlier, but so the state can provide for mental health services to children and other services, which the child has a right to have their parent access or not. And again, children can sometimes challenge that if they don't are not in agreement with what their parent would authorize. The state generally has broad authority to act to protect children, and child protection is only one element of that, or one example of that. And you see some others there. We've already talked about education laws, labor laws, vaccination laws, and so on. I mean, there are a whole array of things that parents must do, or that others must do. For example, when a child is born, in most states there are very specific laws about tests that children must undergo at birth, eye drops that have to be put in the child's eyes to protect against certain diseases, and so forth. So there's a whole welter, really, of these rules that are imposed upon children and parents to protect the interests of the state in the community broadly. The law presumes that every parent is fit to raise his or her children, so that there is no question that in the first instance it's both the right and the responsibility of the parent, and the burden rests with the person or entity that would challenge that parent's capacity. So, for example, if Children's Protective Services goes to court to seek authority to remove a child from the parent's custody, the burden of proof is on that agency to prove that the parent is either temporarily or permanently unfit to provide for that child. While the law presumes that the parent's fit, there's no substantive constitutional right to remain together as a family. So what that means is that the government can intervene in family life to protect children, but when it does so, it must protect the rights of the parent and the rights of the child with procedures that are comport with what we call due process of law. So they have to be fair. That's why you file a written petition when you want to remove a child from a home, and you file a written petition with the court. The written petition puts the parent on notice. These are the precise things that we think that you have done or not done that constitute child neglect or child abuse. The parent has the opportunity to have a hearing to challenge those allegations, and that hearing takes place in front of a neutral decision maker, a judge. Some states permit a jury to make this decision. Some judicial officer will hear the case and decide. In most cases, there's not a constitutional right for the parent or the child to have a lawyer, although most states provide that in terms of their state laws. So state law, this child protection is largely governed specifically by state laws, and so they vary from state to state, and what goes on in your state may be different than what goes on in a neighboring state. It's important to think about the role of the federal government in child protection, because we have this concept in the law known as federalism, where there are certain things that the Constitution assigns to the federal government to be responsible for, and if it's not assigned to the federal government, then it's left to the state governments. So any state, California for example, tomorrow your legislature could get together and decide they want to get out of the child protection business and simply close down your child protection services agencies. They could do that if they wanted to. Let's hope that they don't, but that's a possibility that they could make that decision. The federal government could not then step in and protect individual children in, say, Los Angeles County or San Bernardino County, or or anywhere else in the country. So what the government does, what the federal government does, is that they create huge financial incentives for states to develop child protection systems that look the way the federal government thinks that they ought to look. And they started this initially in 1962 with block granting. So they would give each state a certain amount of money, and the state could use that money in whatever way it saw necessary to protect children from child abuse and neglect. 12 years later, in 1974, they were unhappy with what was going on in the states because they felt too many children were coming into the foster care systems and they were just staying there. There was no plan for the children to be returned to their parents, or there was no plan to move the children on to termination of parental rights and then adoption. And so the federal government began to get involved by providing funding to the states. It's optional. States don't have to take advantage of it, but the states do because the funding is so enormous. It's hundreds of millions of dollars every 3 months, so that the state has a huge incentive to actually comply with the federal law. So in 1974, the federal government enacted the Child Abuse Prevention and Treatment Act, which funds child protection services. And in order to get that money, you have to develop a system that looks the way that the child welfare system, or that the federal government thinks your child welfare system should look. So you see things like mandatory reporting laws, protections for mandatory reporters in terms of civil and criminal liability, and so forth. In 1978, 4 years later, the federal government enacted the Indian Child Welfare Act, which is substantive law. So it's different than the other statutes you see here, because that's a law that the federal government is assigned the responsibility of all of the dealings with Indian tribes around the country. And so the federal Indian Child Welfare Act is substantive, and I put it here because I want you to understand that comparison to these other laws, which are funding in nature. In 1980, the Adoption Assistance and Child Welfare Act established 2 new sections of the Social Security Act Title IV-B funds in-home services programs, so families that are distressed, families that have been deemed abusive or neglectful, but the children are not at such high risk that they need to be removed. Title IV-B funds family preservation services. Title IV-E funds when children have to be removed from their home and placed into the foster care system. That's a separate line of money that supports that work. So that statute did essentially three things. It tried to reduce the number of children coming into the foster care system by requiring that states make reasonable efforts to maintain families and to preserve families. It set time-limited placement in foster care at 18 months when you had to have a permanency planning hearing. And the idea at the permanency planning hearing was you either return the child to the parent or you moved in the direction of permanent placement other than with the parent. And then it created an adoption incentive program to pay certain fees and so forth, and to create incentives for individuals to adopt children out of the foster care system. So the idea was that foster care, we want foster care to be a temporary solution for a limited period of time while we try to work with parents to get rehabilitated, and if parents can't do that, then to move children on to other permanency arrangements. In 1997, the Adoption Safe Families Act, it was Congress's sense that there was too much emphasis on family preservation and children were staying too long in foster care despite the 1980 Act, and so they revised it significantly, made it very clear that the child's safety and well-being are the paramount considerations for making decisions about children in foster care. Just about 2 weeks ago, Congress acted again with the Family First Prevention Services Act, which is largely intended to tap Title IV-E dollars, so dollars that were initially thought of as foster care payment dollars, and get those dollars, make them available to programming to keep children with their parents, specifically around the opioid epidemic, which is kind of the impetus for the 2018 Act. That act is going to primarily start coming online later this year in October of 2018, and so we have yet to see exactly how that's going to work out. So that brings us to illegal use of substances and the illegal use of legal substances. So we're thinking about prescription opioids that might be abused because someone doesn't have a prescription, or they do have a prescription but they're using the opioid outside the prescription. You can think of the same thing with medical marijuana in those jurisdictions where medical marijuana is available. The illegal use of substances is pretty straightforward for child welfare. We go in, they're going to assess what's the risk to the child, what is not being done that the child needs to have done, or what's going on with the child that shouldn't be going on with the child. And they're going to factor into that. Most CPS agencies use some form of actuarial risk assessment tools. So they're looking at how, what's the level of risk? Is this child safe? Is this child unsafe? If this child is not safe, what is the level of risk? Is it a low level? Is it a moderate level? Or is it a high level of risk going forward? So they're assessing a sort of environmental situation to try to figure out how safe the kids are. If there's any of the neglect or abuse that's related to the substance use, then the agency can act. So another way of thinking about that is that there are millions of parents in the United States that have substance abuse problems but never have any interaction with Children's Protective Services, or if they do, their children are not taken away. You have to have a sort of connection, or what legal folks call a nexus, between the substance use or abuse and some harm to the child. So if you can't draw that straight line between mom's using drugs and the child's not getting medical attention, or is getting physically abused, or is being exposed in the home to things that are harmful to the child, if you can't draw that straight line, then there's no concern from a child protection perspective, right? So you go in and you think about there's drug abuse and how is that impacting the child. It's not just mom has a substance abuse problem, dad has a substance abuse problem, these children need to be removed or we need to intervene. You have to show some connection. Prescription use is more difficult, but it can still cause or contribute to a neglectful environment. The mere fact that a parent is using a prescribed medication does not necessarily absolve them from the responsibility to make sure that their children are safe or well cared for. So that a parent might be using opioids in a perfectly legal manner, and it still may impair their capacity to parent their child. If that's the case, then Children's Protective Services can act. Same with marijuana. Same with any other legal substance, right? There may be many drugs that a parent might take that would impair their capacity because it makes them drowsy, because it makes them lethargic, whatever, and they can't meet the needs of their child. That can be part of a case involving neglect. It's important to remember that most state laws, and again, state law will vary on this point from state to state, but most of these laws, there's no intent requirement. So you don't have to show that the parent intended to harm their child or that they intended to neglect their child. All you have to show is that there's some level of parental dysfunction which is resulting in some harm to the child, and then the state has the authority to act to protect that child and to provide for that child's needs. So it's an objective standard of minimal care. So it's important to remember that in most jurisdictions, you don't have to say, well, mom intended this to happen. It doesn't matter whether she intended it or not. We have a poll question here. Has your system seen an increase in substance use or abuse cases since your state's passage? So we'll take a minute and let people respond to that. So it looks like either not applicable or that, a third has, so 32% have. All right. Okay. So I want to talk about substance abuse and substance use during pregnancy. The use of substances during pregnancy has been an issue for at least a century. It started out with alcohol in the 1800s. People, physicians began to notice that children who were born to mothers who were alcoholic were having health problems and were having birth defects. By 1973, we actually called this fetal alcohol syndrome. And that syndrome was, over the last 50 years or so, developed into, as our knowledge developed, has become what we now think of as a spectrum disorder. So you can have full-blown fetal alcohol syndrome and you can have lesser impacts, fetal alcohol effects or fetal alcohol neurodevelopmental issues with the child. The American Academy of Pediatrics has very clearly stated that no amount of alcohol is safe to use during pregnancy. The other drug that we have the most information about is nicotine, so cigarette smoking. Cigarette smoking and alcohol are clearly two of the most well-studied and two of the most harmful substances that parents can use during pregnancy, that moms can use while they're pregnant. One thing regarding fetal alcohol spectrum disorder is in the last 2 or 3 years, there's been a good bit of research, very high quality research done, and what we're finding is that we have either misdiagnosed or missed the diagnosis very often. So it appears that, especially among children coming into the foster care system, these kids have much more prenatal alcohol exposure than we had previously understood. So these kids are at risk for particularly intellectual disabilities. Fetal alcohol exposure is the #1 cause of intellectual disability in the country. So it's important to assess children who are coming into the foster care system or children with whom we are working in their family home and substance use during pregnancy is suspected. It's really critical to get an assessment of whether or not there's fetal alcohol exposure, because it's more prevalent than we thought, and it's also much more impactful than many of the other substances that we, at least in our current state of knowledge. While the drug of concern changes, the basic concern does not. So, for example, just recently in the last few years, we've seen this substantial increase in neonatal abstinence syndrome around opioid use. But there have been waves of the drug has changed, from alcohol to marijuana. In the early 90s, there was the crack cocaine. After that, it was methamphetamine. Then we had the opioid crisis. And now, as the authorities have begun to crack down on opioids, we're seeing an increase in children born exposed to methamphetamine again. One thing to be aware of when we talk about the impacts of drug and alcohol use on preborn children is that the mother who uses alcohol, who smokes marijuana, is very likely to do other things. So a mom who smokes might smoke marijuana, she might smoke cigarettes, she might drink alcohol. And so you'll see children who are born with 3 or 4 substances in their system, and you'll see, where there's one substance, you should be aware of and concerned about the possibility of the use of other substances. And research is trying to pick apart to understand what exactly is the impact, say, of cocaine use during pregnancy, what exactly is the impact of marijuana use, but it's very difficult because very often the parent has used more than one of these substances, and it's sometimes very difficult to say, cocaine causes X, Y, and Z outcomes. Over the years, we've developed some information about this, but we always have to be aware that many of the moms are polysubstance users, so we want to know that. CAPTA, the Child Abuse Prevention and Treatment Act, specifically addresses the issue of prenatal exposure. Infants born with and identified as being affected by substances or withdrawal symptoms must be reported to CPS. It does not define this under federal law as being child abuse. So, for example, your local hospital, if a child is born and that child is identified as being prenatally exposed, the doctors have a responsibility to report that to CPS, but that doesn't necessarily mean that that constitutes child abuse or child neglect under the state definition. And many children are born exposed, and CPS does not do an investigation, or if they do an investigation, they do not take any action. They don't substantiate the case, if you will. And again, state law is going to vary on that, as well as individual policies at the state level that individual agencies have in place. And the federal law does not require criminal prosecution of a mom who uses drugs or alcohol while pregnant. So the state law is one area where state law varies quite widely, is whether the report is for any exposure or if it's only where the child is actually addicted or the doctors can point to some specific health impact. So for example, here in my home state of Michigan, any exposure that's identified must be reported to CPS. In the state of Maine, by comparison, the child has to either be born addicted or the doctors have to be able to specifically diagnose X problem is the result of mom's use of substances while she was pregnant. So that your state law will vary on that issue in particular. So what about the proper use of legal substances that may cause harm? We have a number of cases around the country where moms use legal substances that are prescribed by the doctor. So for example, methadone. Pregnant women are encouraged to take methadone or other chemically enhanced treatments like Suboxone and so forth, because they are less harmful than using other opioids. So it's better that mom's using methadone than she's using heroin. And so the doctors will prescribe methadone for a pregnant woman, but it's important to understand that still has an impact on the inchoate child, the child who is not yet born. So for example, this New Jersey case, the child was born and immediately went through withdrawal from methadone, because methadone is a form of an opioid. And so the child went through withdrawal symptoms, and the question for the court, the New Jersey Supreme Court, was, does this constitute child abuse or neglect that this child was exposed to methadone and born and immediately after birth went through withdrawal? And basically what the court said is, not in and of itself, as long as the methadone is prescribed by a doctor and the mom is using it consistent with that and not abusing it, then that in itself is not considered child abuse and neglect under New Jersey law. And so states may vary here. It also, the New Jersey Supreme Court also said, even though that's the case, you can look at other things. And this is what child protection agencies typically do. It's the prenatal exposure plus the postnatal environment, which is critically important, in terms of the child's reaction to being born exposed. So one of the issues that comes about is how long does the agency work with the parent before they take action if the parent's not, getting into drug treatment or is not going for assessments and that sort of thing. So your state law and your state practice will vary based upon that, on their policies, but the idea is it's the prenatal environment plus the postnatal environment, which is typically going to result in the determination of whether it's neglect, where the parent has used the drug consistently with the doctor's prescriptions and supervision. I presume, although I haven't found a case on this, I presume that cannabinoids would be treated the same where they're being used during pregnancy as a medication for medical purposes. I would assume, it's a little bit sketchy in some areas and some doctors in terms of the prescription for marijuana. Some of these doctors that are prescribing it are quite irresponsible in my view, and so the legitimacy of that might be open to question in particular cases. So I want to talk about the fetus and the inchoate child in terms of the protection of newborn children. So I think everybody probably knows what a fetus is. I think of an inchoate child as a child who the mother has determined she wants to bring to term, or she has not made that conscious decision and time has passed and she can no longer legally terminate her pregnancy. So this is a child who's going to be born And the question is, what is the state's interest in this child? So I want to step back and just mention Roe versus Wade again. So Roe versus Wade, you may recall, set up a three-part to the pregnancy: the first trimester, the second trimester, and the third trimester. The Supreme Court held that the state always has a substantial interest in a fetus and in the welfare of the mother. So the state can regulate pregnancy. It can regulate mom's behavior during pregnancy, and it can regulate that both for her own health, and it can regulate that for the health of the fetus. So you can think about drug usage. You can also think about an employer might decide that the state may allow employers to make decisions about whether or not a pregnant woman can work around certain chemicals and that sort of thing. So the state can regulate for mom's health as well as the fetus's. Once the child arrives at a point of viability, then the state's interest escalates from being a substantial interest to being a truly compelling interest. And so for that reason, then the state can, for example, ban abortion in the latter stages of pregnancy because it's in order to meet its compelling interest in the welfare of that child. And over time, obviously, medical technology has gotten better, so the point of viability has been pushed earlier and earlier in the pregnancy. So I don't want to get into those kinds of arguments and questions. So I think of an inchoate child as a child who the mom has either decided as she's going to bring to term, or time has passed and she can no longer terminate the pregnancy legally. So some states have defined the fetus or the inchoate child as a child within the meaning of their statutes. So within the meaning of their child protection code, some states have said when mom's pregnant, that fetus or that inchoate child is a child within the meaning of our child protection laws, which is going to determine how the state thinks about that child as a separate individual from the mother. If it's a child within the meaning of state law, then some states will impose criminal penalties for drug usage. Examples are South Carolina and Tennessee, where a woman who uses drugs during pregnancy could be criminally prosecuted for child endangerment, child abuse, some kind of a homicide if the child dies. So there are various cases involving various charges regarding criminal prosecution of women who use drugs during pregnancy. A few states, for example, Wisconsin, allow the state authorities, or in some states a private individual, to petition the court to commit a pregnant woman who's using drugs for the purposes of drug treatment. So this is just like a woman who would be committed because she's suicidal or homicidal and she's a danger to herself or others. She's entitled to a hearing, and the court would make a decision about whether or not she should be removed from the community and placed in some sort of a treatment program. The constitutionality of these statutes, there's only 3 or 4 states that have these statutes at this point. Their constitutionality is being very aggressively challenged right now, and the Wisconsin case, for example, the Wisconsin District Court said it is unconstitutional as applied to this particular woman, and the state has appealed it, and it's now before the 7th Circuit Court of Appeals. So we don't know the answer to whether or not these statutes will survive a constitutional challenge. That's yet to be determined. Very recent federal changes that I mentioned earlier may provide greater access to treatment. The fundamental problem, or one of the fundamental problems, is there's not enough treatment space for women and specifically for pregnant women. There are many drug treatment programs that won't take pregnant women, and there simply are not enough treatment slots for women who need treatment while they're pregnant. So that's a major issue. And one of the changes in the recent law a couple of weeks ago that amends Title 4E is to try to get more money available to provide more drug treatment generally and more specifically for pregnant women and for parenting and for parents, I would say, too, because part of that statute allows the state to fund treatment programs that will take the parent with the child. So whether it's a mom or a dad, inpatient treatment with your child. That should be available starting hopefully this fall. Generally speaking, in terms of the afterbirth, there's a strong consensus across the country that courts can't take custody of children until they're born. So the court cannot take custody of a preborn child and say, you know, we're going to dictate what happens with this child. Other countries allow that. For example, Holland, the state can take, you know, the government can take custody of an unborn child and essentially assign a social worker to, you know, monitor the mother's constant behavior to make sure she's not using drugs and so forth. But so far in the U.S., courts have been unanimous that this is not appropriate. Some state courts have ruled that prenatal use alone is not sufficient to constitute child abuse or neglect, so that the state can't necessarily act immediately after birth. Because the newborn was not a child, quote unquote, within the law when the drug abuse took place. So if the law does not consider a fetus or an inchoate child to be a quote unquote child within their child protection statutes, some states have said you can't consider what happened pre-birth after birth. You've got to wait until there's some abuse or neglect after birth, or you've got to be able to show some impact from that prenatal exposure. A number of states have ruled, though, that a child has a right to be born of sound mind and body, so that prenatal use in and of itself would constitute a basis to remove a child from a home. California has done this. Michigan, my home state, has done this. The state of Ohio, those are just examples. There are a number of other states who've done this. But they've said a child has the right to be born free of illicit or illegal drugs, and if you give birth to a child who's exposed to methamphetamine or cocaine or whatnot, the state can immediately remove that child from your custody upon birth. A number of other states have not framed this as a child's right to be born healthy, but they have decided that they will consider the prenatal conduct of the parent and after the birth to determine whether or not to remove that child. So, for example, in December, the Pennsylvania appellate court held that a pregnant woman who was using drugs, the state could step in and remove her child immediately upon birth. Although it didn't frame it as the child's right to be born healthy, it framed it more as the state's interest in protecting children. So that's the basic presentation that I wanted to provide. I'd be happy to take questions if there are questions. There were a few questions submitted ahead of time, and so I'm happy to address those. So the first question, oh yeah, go ahead, Jared.
Oh yeah, I was just going to chime in. So yeah, feel free to address those questions that were submitted by registrants and people who were registered in advance. But I did just want to call out that there has been a really active chat group and some really interesting points that were made during your presentation. One clarifying point that someone had brought up about children not necessarily being born addicted, that's more of a drug-seeking behavior, that children are born exposed and may be dependent. This person was making a distinction, a really important distinction. And yeah,
right.
some really good conversations as well. Go ahead, Frank.
Yeah, so children can be born at various levels of exposure, right? So it could be some moderate exposure. It could be that they're born with some impacts. It could be born that they're born fully addicted. So it may, you know, there's a spectrum or a continuum, and children may be born anywhere along that continuum. one of the questions that was submitted ahead of time is, how can growing cannabis impact child safety or assessment of risk and safety? So the question really is, how do you think about the growing of cannabis, and I'm assuming in a home, not in a kind of industrial kind of situation, but if you are growing cannabis in a home. And there's actually been some research done on this question. Some of the things that Children's Protective Services should be concerned about are exposures to chemicals, like many folks who are growing marijuana in their homes may be using pesticides or fertilizers on those plants. Because marijuana does best in warm, humid environments, you might think about mold growing in the home. That may impact children, particularly who may be vulnerable to asthma and other kinds of respiratory issues. Many children who are in homes where where they're actually using growing large amounts of marijuana have respiratory problems because of exposure to these chemicals, and they may have dermatological problems because of skin exposure. So you can think about the physical plant of growing marijuana. So things like heat lamps. Are children being exposed, are they touching heat lamps, that kind of thing? Is that a risk factor for them? I've seen some of these cases where they have really sort of faulty wiring, which is a real risk in terms of fires and the child being electrocuted. That is sometimes an issue in these cases. If the family is living in a rental home or a rental unit of some sort, growing marijuana can impact their ability to maintain their housing, and so housing can sometimes become questionable and problematic. If you're doing this and it's not legal, sometimes you have issues around kind of illegal behavior and unsavory folks that may be attracted to that, which can sometimes present risks to children. There was a study in Canada that found that 30% of the children living in homes where marijuana was being grown were testing positive on hair follicle samples for the presence of THC. So some way or other, those 30% of the children in that study had been directly exposed to the THC in the marijuana because it was showing up in their systems, even though the children didn't show any clinical signs of having been exposed. So that's something that you would want to think about. If a parent is growing, whether it's legal or illegal marijuana, it would impose a higher burden on them to make sure that whatever they're doing in such a way that it's protecting their children from exposure. Another question is, are there any child welfare assessments that address child safety in the home that are cultivating marijuana indoors? I don't know of any specific assessment tool that looks at that issue, growing marijuana. But most actuarial risk assessment tools have some element of environment. So they're looking at the state of the home. Is it reasonably clean? Is it cluttered? Is it filthy? They're looking for things like exposed wires, rodents, and that kind of thing. And so I would assume that most of those would capture that, even though there's not a specific risk assessment tool that I'm aware of for marijuana in particular.
Excuse me, Frank.
Yeah.
Just to call your attention to your QA presenter pod, there were 2 more questions that were submitted. I'm wondering, or 3. I'm wondering if you could tackle those.
Sure.
Right now.
In foster care, can the fact be known if the child was born addicted to a substance? Well, it can certainly be known in the sense that it would be alleged in a petition. So a doctor, in the hospital, the medical personnel might test the child many children would go through withdrawal symptoms, and so that would certainly be known in that it would be put in a petition by the CPS, the Children's Protective Services worker, would allege that the child was born, exposed or addicted to the substance, and then that would be litigated in that way. Yes. The second question: what about breastfeeding while using marijuana? I don't know a lot about that. I would encourage you to go to the Academy of Pediatrics, the American Academy of Pediatrics. They have guidelines for this. I mean, I'm sure. My sense is it would probably be discouraged, but I don't know the specifics about that. But if you went to the American Academy of Pediatrics website, I think you could probably find information about that. The next question: what about kids sitting in the house and the parents are smoking marijuana in the house? This person is in Washington State, and it's legal on a state level. So if a parent can use legally, right? So the question would be, most states that have legalized either recreational or medical marijuana disallow it for minors in the same way that you would disallow alcohol use by a child. So I would think about it in the same way. If a parent were to give a child alcohol, that could be considered parental neglect or abuse. Same with smoking marijuana in the child's presence. You could certainly think about that as being abusive or neglectful behavior on the part of the parent. And children who are exposed when they're very young and prenatally have, the research is very clear that there are a number of very concerning outcomes for these children. For example, kids who are exposed in this way have sleep disturbances at higher rates than children who don't have that exposure. They have lowered verbal and memory acuity, so they have IQ problems oftentimes. They're more likely to be hyperactive. And young children who are exposed prenatally and probably in the early stages of life who are exposed to marijuana, in the long term, the longitudinal studies are telling us very clearly that these children are at high risk for delinquent behavior as young as 10, and by 14, quite seriously, quite elevated risk by 14. So there are a number of concerns about the problems of exposure to marijuana. So even though it's legal for the parent to smoke it, I would anticipate that an agency could very well say, if you're exposing your children to the secondhand smoke of this, and they're testing positive, it's getting into their system, then you're doing harm to that child developmentally.
Okay, I think that's all the time we have for today. I do want to thank you, Professor Vandervoort, for your time, and if folks have any other questions, his contact information is on the slide. So I'm going to pass it over to my colleague Molly here, who's going to close us out.
Yes,
Thank you.
Again, Dr. Vandervoort, and thank you everybody for attending. Make sure to look out for an email with a link to a short survey on this webinar. At the end of that survey, you will have a link to your webinar completion certificate. So thank you everybody, and have a great day.
Thank you.